Kaajal, Ramjathan-Keogh is the director of the International Commission of Jurists Africa program. She joins us now. Kaajal, good afternoon and thank you for your time. It seems from what I can see that Israel is simply arguing about the evidence. They claim the evidence we brought is not true. And look, we've all seen for ourselves to an extent what's happening in Gaza. Can Israel really do that? Just attack the evidence? Will that work as a legal strategy in a case like this?
Certainly not, Stephen. You cannot just attack the evidence without providing any new evidence or your own evidence to counter what has been shown to the court already. We've seen in the hearing from this morning that a significant part of Israel's response was to attack South Africa for misleading and lying to the court. What Israel was saying is that South Africa purports to come to the court as the guardian of humanity, but it has an ulterior motive. And this ulterior motive is part of its military advantage for its ally, Hamas. So it's making very strong statements about South Africa's support, active support of Hamas. No evidence has been provided to the court, to anybody, that it's making these statements to the court. Israel has also been saying, and it insists, it has the right to defend itself. However, South Africa is adamant that there is no right of self-defense by an occupying state against the territory that it occupies. So there are very strong factual differences and legal differences, and both sides have provided evidence to the court about what one side sees as genocide and incitement to genocide, and Israel sees completely something else. So there is a very serious issue of what evidence has been provided to the court, and the court needs to sit now and deliberate on this. And South Africa has requested urgent, emergency, provisional measures, so the court really should not take a long time in its deliberation and needs to act quickly.
How do the judges decide what's true and what's not? I mean, we saw yesterday a video, I presume verified in some way, of an Israeli military leader telling Israeli soldiers to go in and destroy Gaza. I mean, surely that's true. I mean, does the judge now have to go and look at the coding of the video?
Well, you know, various different pieces of evidence, various evidence is given a different weight by a court depending on where it comes from, whether it's been verified, the authenticity of a particular piece of evidence. There are many sides who are saying that a lot of the evidence being provided to the International Court of Justice by both sides is hearsay evidence. In the circumstances, however, this is the best evidence which can be procured in the circumstances. One must also bear in mind that there were certain media outlets, Al Jazeera in particular, that was operating in Gaza, and they have been banned. So it's now getting more and more difficult to get genuine, believable media coverage. On the ground in Gaza, in Rafah, there are local media outlets available, but Israel will then contest that evidence coming from local media outlets because of the particular stance that they might take.
In the past, one of the arguments that Israel made, it said it had to attack Gaza in this way because it had to free the hostages taken by Hamas. And in a way, I think, you know, depending on how you look at these things, that could have been one of the stronger arguments that they presented. They had no choice. They had to go and protect their citizens. It was around 200 people taken hostage. Now, over 30,000, 35,000 Palestinians have been killed. I know Israel will dispute that, but I think we can by and large accept that figure. So does that argument that Israel's only going in to retrieve its civilians, its hostages, does that argument just not work anymore? 200 people versus 35,000.
I don't think that argument has ever worked. That is just Israel's excuse for invading and attacking and bombing all of Gaza. And that excuse has been used from the start since the 7th of October and continues to be used. We don't know how many of those hostages are still alive, how many are still being detained by Hamas, whether they have, you know, we have very little information on the situation of the hostages. And this is because Israel has not allowed independent monitors, independent fact-finding, anybody into that territory to try and ascertain what is going on. So Israel cannot complain about the absence of genuine, authenticated information and evidence when it's not allowing and facilitating access to be able to compile and gather this evidence.
There are a couple of things going on here, and Kaajal, you'll probably understand this better than I do, but yes, there's a legal argument, but I mean, these arguments are live on international television networks, and so this is also about the court of public opinion. And I think this court case and the arguments that we see may show a bigger dynamic which is happening around the world, which is sort of different, in other words, to what the Israelis see. So it seems to me that maybe we have a situation now where much of the world, certainly the global south, can see the situation in Gaza and recognize it as a genocide. People in Israel see it so differently. They dispute the numbers, they dispute the border crossings being closed, they dispute everything. And what worries me is that when you have any kind of conflict, when you have two different groups of people basing their decisions on completely different sets of facts, there's really no prospect for it to end, if that's the case.
It is an extremely, extremely difficult situation. South Africa has presented one position, Israel has contested that position and has presented a completely different position about what is happening in Gaza and in Rafah. In this particular instance of South Africa approaching the International Court of Justice, they've said it at almost all the lawyers have said they were prompted to appeal to the court again for another hearing and for additional provisional measures on account of what they saw was happening in Gaza. Israel, on the other hand, is saying something completely different. While South Africa is saying that they've closed off the crossings, there's no access or very limited access to humanitarian aid, very poor access to medical treatment and care, Israel is saying something completely different. South Africa has provided strong evidence to support all of the statements and contentions it is making. Israel has provided some evidence, not very strong evidence. Their arguments in court this morning were mostly to deny and refute without providing a huge amount of evidence. So the court remains in a difficult position, but the court, as we've seen in the previous hearings, has been fairly conservative and has been cautious in how it has dealt with requests for provisional measures. And I'll talk about the provisional measures a bit more in a little while.
Kaajal, I can't help but feel, I'm not a lawyer, but I wonder, I mean, the legal arguments are very important, and I think this entire issue has been very important because of the point I made about the court of public opinion. And we see public opinion crucially in the United States changing. But there's a part of me that says, to a group of Palestinians living in a block of flats, does it really matter if someone blows their block of flats to smithereens, whether it's, you know, a legitimate act of warfare or genocide? And it's one of those situations where people, very clever people, people with the best motives, are on one side at least, are having an argument about this at The Hague. But it doesn't matter if you're a Palestinian who's lost every member of your family, because now some people in The Hague are having an argument about whether the loss of their children was genocide or just part of war. I mean, I hate to say this because I don't want to dispute your profession, but there's a hollowness to it for me.
Absolutely. Courts are not well equipped to deal with emergency situations and conflicts such as this particular conflict. However, in the context, there's not any other avenues that Palestine can seek or can appeal to get some kind of resolution to the difficulty that they are facing. South Africa has intervened on behalf of the Palestinian people before the International Court of Justice. But this court, as all other courts globally, local courts, national courts, regional courts, international courts, operate slowly. We cannot rely on courts to provide the kind of solutions and to bring peace that we're looking for in the Middle East. So this particular hearing will proceed in its own timeline, and that timeline might not work for the Palestinian people, and it might not work for trying to establish a ceasefire and trying to save lives in Gaza and in Rafah. And that's the reality that we're living in. You can't rely on those judges and on the lawyers in both those teams to try and work this situation out before court. we need much stronger intervention, and we're not seeing that from any other parties.
You talked about the provisional measures. If our case is successful, and I'm afraid to say it's probably by no means sure that it will be, what difference would it make? I mean, it wouldn't bring, I presume it wouldn't really bring an end necessarily to the combat mission in Israel's combat mission in Gaza.
No, I mean, South Africa at this instance has requested, first and foremost, that Israel withdraw from Rafah and cease its military offensive in Rafah. It's also asked again, and it's asked this before, to facilitate unimpeded access to humanitarian aid and assistance. And it's asked that Israel must submit reports to the court on measures taken, and this is on previous provisional measures which have been ordered by the court. Report to the court on what steps they've taken to facilitate and abide by those provisional orders. What is interesting in the circumstances is that South Africa has now applied multiple times for various provisional orders. During the first request, they asked for ceasefire. The court did not grant that. During the second request, they did not request measures directly. Instead, they requested the court to consider whether the developing circumstances in Rafah require that the court exercise various powers under the court's rules. The court refused to grant that request. The third time, South Africa requested provisional measures, which would have ostensibly covered Hamas and hostages as well. The court said it could not order that ceasefire and could not make such an order because it has no power over Hamas, and it could not make an order that was not enforceable, and that was an order against Hamas conducting the actions that Hamas was doing. After the third request, however, there were several judges that thought that the ceasefire should have been ordered. And they said because it was impossible to ensure the delivery and access of effective humanitarian aid, which was previously ordered, while the bombing and attacks were ongoing. So, the court seems to start to soften at the third instance. South Africa is now making a fourth request for provisional measures, in which it does not draw in any non-parties to the proceedings like Hamas, but it makes a request based on a clear geographical limitation, which implies that Israel could continue operations elsewhere as necessary, but that it needed to be more careful with regard to operations in Rafah on account of the huge number of people in Rafah, the fact that they cannot leave Gaza, that the fact that they cannot get aid coming into Gaza. So, as cautious as the court has been previously, I think the South African team is extremely hopeful that the court is going to make a stronger provisional measures in the circumstances. But we must also bear in mind that we are still at the very preliminary stages of this court process, and we are only dealing with emergency measures at this stage. We still have to get to the point where both South Africa and Israel will have to deal with the issue and argue on the issue of genocide, whether there is a genocidal intent, whether genocide is being committed, and that is still months away.
Kaajal, Ramjathan-Keogh, thank you. Really appreciate the time and the insight. The Director of the International Commission of Jurists Africa Programme.